Greetings to you all, ladies and gentlemen. Welcome to Global Justice Talk, your informative, inspiring, and educative channel. Uraya Chikwetu is my name. I am a lawyer based in Harare, Zimbabwe. Today's topic might be a bit stressful, but very important for both employers and employees in Zimbabwe. The topic for our discussion is on damages for wrongful dismissals. Getting fired unexpectedly can be a nightmare. But do you know your rights and obligations if this happens to you unfairly? Well, stay tuned as I unpack these issues in this video. Firstly, I am going to deal with the scenarios where wrongfully dismissed employees receive damages. Secondly, I will delve into the duties of wrongfully dismissed employees to mitigate their losses. Thirdly, I am going to assist you to understand how damages for wrongful dismissals are calculated. Finally, as I close, I am going to demonstrate how punitive damages arise and the factors that the courts consider when awarding punitive damages, as well as the purpose that punitive damages serve in our labor law. By the end of this video, you will have a clearer understanding of your rights and obligations, helping you to navigate these complex issues with confidence. Whether you are an employee or an employer, this video is for you. I encourage you to subscribe to the channel, like this video so that YouTube can show this video to a larger audience. At the same time, before I venture into the next segment, I encourage you to leave your comments and also to share this video with your connections and friends. This will assist a number of people because YouTube, by virtue of your subscription and the comments, YouTube will show this video to a larger audience. We now move into our next segment where we are going to discuss the scenarios where wrongfully dismissed employees receive damages. What are the scenarios? There are two main scenarios here. Number one, damages are awarded at the discretion of the adjudicating authority where reinstatement is found to be inappropriate in the circumstances. Number two, damages are awarded by reason of Section 89, subsection 2, paragraph C, subparagraph 3 of the Labor Act. This provision allows the court to grant reinstatement if it finds it to be more appropriate and must specify the damages that are awarded to an employee as an alternative to reinstatement. Damages here are awarded as an alternative to reinstatement, not as the primary or main remedy. The employer in this case is given an election to choose between these two options. Basically, those are the two scenarios where wrongfully dismissed employees receive damages. Before I move on to our next segment, I once again invite you to subscribe to the channel and also like this video so that YouTube can show this video to more audience or to a larger audience. You should not also forget to comment and share this video with your friends. To our next segment, we now focus on the duties of employee or the duty of wrongfully dismissed employee to mitigate his or her losses. Now, here is the catch. Unfairly dismissed employee can't just sit around and do nothing. This has been emphatically confirmed by the court in Ambali versus Buttershoe Company Private Limited. In this case, the court stated that wrongfully dismissed employees must mitigate their losses. This is achieved by searching for or actively searching for alternative employment. The court will assess or will look at the employee's efforts to secure alternative employment when calculating damages. If the court feels that the employee did not do enough to secure alternative employment, it will reduce the damages that it awards to the wrongfully dismissed employees. Then we need to answer a certain question here. Does mitigation of losses mean searching for formal alternative employment? The mitigation of losses cannot only be achieved by searching for formal alternative employment. Selling vegetables, repairing other people's shoes and equipment can be regarded as a legitimate way of mitigating losses. A good example of a case where this was demonstrated is the case of Olivin Industries Limited versus Narara. In that case, the income that the employee earned when repairing other people's cell phones and selling vegetables was taken into account. The court considered this type of work as one of the legitimate ways in which mitigation of losses can be done. Once it is accepted that the employee has attempted to find alternative employment, it should be accepted that the employee did not sit around and do nothing. Basically, those are the ways in which mitigation of losses can be achieved. Before we move into our next segment, where I am going to discuss how the calculation of damages for wrongful dismissal are done, I once again invite you to subscribe to the channel and also to like the video so that YouTube can show this video to a larger audience. We now move into our next segment where I am going to discuss the way in which damages are calculated for wrongful dismissals. As a general rule, the damages for a wrongfully dismissed employee will look at the salary that the employee would have received for the unexpired period of contract of employment. Even if your case is related to a contract of fixed duration, the unexpired period of contract of employment does not necessarily mean the amount of time remaining up to the end of your contract of employment. At the same time, if your case is related to a contract of employment of no fixed duration, the unexpired period of contract of employment does not necessarily mean the date of retirement for the employee. For all these cases, or contracts, the unexpired period of contract of employment is the reasonable time it will take the wrongfully dismissed employee to secure the similar work or similar employment. So it is very important for the employee to observe that. At the same time, the calculation of the damages will be employing the rate of pay that was applicable at the time of dismissal as opposed to the current rate of pay. The court will also use net pay as opposed to gross pay. What is also important to observe is the evidence that must be shown for the quantification of damages. For us to understand that, we need to understand the difference between damages that can be assessed with the exact mathematical precision, and those damages that cannot be assessed with the exact mathematical precision. Where damages can be assessed with the exact mathematical precision, the employee will need to show evidence of the rate of pay by simply showing the rate of pay in the pay slip, or in the contract of employment, or in the collective bargaining agreement. Where the rate of pay or the damages cannot be assessed with exact mathematical precision, the court cannot engage in an act of guesswork. The court still needs to be given evidence. In this case, the employee needs to lead evidence of the rate of pay, so that it can be able to quantify the damages. In this case, the evidence that the employee is the one that is available, which can assist the court to quantify the damages. So basically, those are the ways in which damages can be calculated. Then we need to move into our last segment. But before I do that, I once again invite you to subscribe to the channel and like this video, so that YouTube can show this video to a larger audience. Our next segment will be discussing how punitive damages arise, the factors that the courts consider when awarding punitive damages, and also the purpose that punitive damages serve in our labor law. What are the circumstances that give rise to the award of punitive damages? The scenarios are found in section 89, subsection 2, paragraph C, subparagraph 3 of the Labor Act. A close reading of that provision revealed that punitive damages are awarded where damages are awarded as the only remedy. The court would have found that reinstatement or the employment relationship between the employer and the employee is untenable. And the reason the employment relationship is untenable is because of the wrongful dismissal by the employer. Hence, the need to award punitive damages. What are the factors that the courts consider when awarding punitive damages? Basically, there are three factors. Number one, the court will look at the severity of the employer's conduct. In other words, the court will look at whether the employer has acted with malice, recklessness, and deceit. The second factor that the court look at is the moral blameworthiness of the employer. Was the conduct of the employer bad? That is what the court will look at. Then finally, the last factor that the court will look at is the comparable cases. The court will look at the precedents. In other words, the court will look at the current facts and the facts of the previous cases, and be able to determine the punitive damages that it can order the employer to pay. Then we move on to the purpose that the punitive damages serve in our labor law. The punitive damages are meant to punish, deter, and set an example. But what must be observed is that punitive damages are mainly meant to punish, and they are in addition to compensatory damages. And as such, they are expected to be reasonable. So basically, those are the points with regard to how punitive damages arise, the factors that the courts consider when awarding them, and also the purpose that punitive damages serve in our labor law. Understanding these concepts is very empowering to both the employer and the employee. For the employee, this will assist the employee to be able to fight for a fair compensation. And for the employer, this information or this knowledge will assist the employer to minimize the risks that emanate from wrongful dismissals. Once again, I encourage you to subscribe to the channel and also to like this video. Don't forget to leave your comments and your questions in the comment section, and also to share this video with your friends. Another issue that I want to highlight is that this discussion is just a general talk on the subject matter. It cannot be regarded as legal advice. If you have got a burning issue where you need legal advice from a legal practitioner, I encourage you to seek that legal advice for your specific situation so that you can be given a specific advice to your specific situation.